Don't you know that I dance to the more of the three I really had that night with Daddy D. He was swinging on the sax with the terrible tune, and I was dancing all over the room. Don't you know the people were dancing like they were ready? The swingin'est band they had ever had, and the swingin'est song they could ever be. It's a night with Daddy D. Let me tell you that I never had it so good. Yeah, and I know you never did until you get that piano with that jive. I shake a band like the Church Street Five. Don't you know that I did?
Good evening. I'd like to call to order the regular meeting of the City Council, City of Lakewood, Colorado, December 11th, 2017 at 7 p.m. in Council Chambers. Will the clerk please call the roll?
Paul.
Here.
LeBure.
Here.
Skilling.
Here.
Gutwein.
Here.
Franks.
Here.
Harrison.
Here.
Roybal.
Here.
Vincent.
Here.
Abel.
Here.
Johnson. Beta.
Here.
You have a quorum.
Fantastic. I'd like to welcome everybody who's come out tonight to join us, or those who may be tuning in via other channels. One thing I'd like to mention before we move on to the Pledge of Allegiance, if you plan on participating in public comment tonight, please get signed in. Unfortunately, over the last couple weeks, people have been left out or have been gone over because we haven't been able to kind of keep a good handle on that. So if you're going to speak, please sign up, and we'll make sure that we keep those back there for a little bit extra time so that you can get signed in, and that way we have all that information. All right, will you please join me in the Pledge of Allegiance and remain standing for a moment of silent prayer? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. All right. So we are going to move on to our next agenda item, which is a little bit of a city council orientation, but it's really, I think, good information for the public as well as the city council with new city council members to get a little bit of a legal overview on some of the issues that can be a little bit tricky or have interesting parts to them, I guess you could say. So with that, I'm going to invite our Deputy City Attorney Greg Graham up, and he's going to break us in, and if council has any questions, we can go from there. And I'm sure they will, since we have a couple of attorneys on board now. Right? All right.
Good evening, Council. Mr. Mayor, thank you for the opportunity to speak to you this evening. This is going to be a pretty brief overview of what we call legal basics for city councils, town boards. I assume most of you, or some of you, the newer members of the council, have the opportunity to see the presentations earlier this evening. I believe there was an orientation. And I'm sure if you had the opportunity to see the one that Mr. Cox did, I imagine he talked about me a lot. So you're probably very, very familiar with me already, just through Tim. But I'm going to go through this. This is going to be pretty quick. If you have questions, let's wait till the end, because there's really only a couple of slides per item. And I'll sit back down and I can answer questions. Tim can answer questions. And it didn't work. There we go. So tonight, these are our basic topics, 5 things. We're just going to start off with 5 things. The first one is open meetings. That includes executive sessions. Open records, once again, just the basics of all this stuff. Quasi-judicial proceedings. We will not get into details about quasi-judicial proceedings because that is its own topic and it can take a long time. Conflicts of interest, and then finally a little bit about governmental immunity. Open meetings and executive sessions. So, not surprisingly, open meetings, meetings of all public boards, that means governmental boards, councils, commissions, committees, whatever you want to call them, must be held in public. It's pretty basic. State statute defines what a meeting is, any kind of gathering, right? Generally, it requires at least 3 or more individuals where public business is going to be discussed. That must be open to the public. Now, there's a little parenthetical there on number 3 that says also posted, question mark. What does it need to be posted? We generally err on the side of yes, it does. But if you actually read the statute, the meeting has to be open to the public, but it doesn't say anything about posting until it gets into the next one, which is a quorum is present, policy might be adopted, formal action might be taken. That has to be posted, and it says that expressly in the statute. So that's interesting because it doesn't say posted, when 3 or more people happen to be together. But in number 4, if it's policy is adopted, formal actions taken, then it has to be open and posted. Chance encounters, social gatherings, as long as business is not the central purpose of the meeting, those don't qualify as meetings under the open meetings law. There's an interesting case, Castilla County case, which we look at a lot, where a couple of county board members, commissioners, happened to go to a presentation. Technically, because it's county, it had 3 board members. That's a quorum. Quorum was present. Some discussion of what could potentially become city business or county business was discussed. That was determined not to be an open meetings violation because the primary purpose of that was not to discuss county business. So that's open meetings in a nutshell. Executive sessions are an exception to the public meetings requirement. So executive sessions, as you probably all know, are meetings held by a government board or council that are held in private. And typically only the council and specific invited staff members, the city attorney, city manager tend to attend those. One of the most important aspects of executive sessions is they should be used sparingly, largely because we don't want to abuse the authority. We don't want to go into executive session for everything, anything. Back 10, 12 years ago, a client I had in private practice, if the clock had not hit 11 o'clock by the end of their city council meeting, they would just call an executive session because they had plenty to talk about behind closed doors. That was sort of a bit of a no-no. Don't do that. We don't do that. There's some case law that's kind of changed how we look at how we post meetings, discuss meetings, that kind of thing. But in an executive session, those discussions are confidential. You need a motion to go into executive session. It has to be in strict compliance with the statute, which means you have to identify the purpose of the executive session. You have to cite the statutory provision that allows you to go into executive session. And an improperly called executive session could result in an injunction. It will result in the award of legal fees. And in some cases, it will undo whatever decision came out of that. Now, there are ways to deal with that, to sort of ratify those actions. Sometimes they're just undone. You have to go through an entire process to fix whatever it is that was done in the executive session that was not called properly. I would note that the city has its own executive session rules. It's in the charter, and we have some slight differences. Let's see if that's up here. Yes, it is. This is in the charter section 2.51. These are paraphrased to kind of cut them down, but these are your basic reasons that you can go into an executive session in Lakewood. The statutory provisions are slightly different. We have a little bit more leeway in Lakewood when it comes to negotiating and discussing negotiations. But for the most part, the rest of them are generally in line with state statute. One interesting matter with executive sessions is they do have to be recorded in the same manner that you would record a regular session, unless you're getting advice from your city attorney, in which case no recording is necessary. There doesn't have to be a specific record of that. Speaking of records, open records. So generally speaking, the business of public entities should be conducted out in the open, not behind closed doors, unless it's an executive session. And there are good reasons for the executive session, which if you check that out, you sort of understand why. You can ask questions later if you have questions. So most documents held by the city, by any government entity, are considered public records. And it doesn't have to be paper documents. It can be electronic documents. It can be a database. The Open Records Law has recently changed and expanded the kinds of things that we kind of have to provide when we're responding to an open records request. Probably the best practice is to assume that everything that you write down, whether it's electronically or on paper, is going to be open to the public. It is considered city business, as long as it is city business. If you're just, writing your grocery list while you're listening to me talk to you, then that would not be city business, and it wouldn't be subject to an open records request. Emails, sometimes they constitute a meeting, but they are also nearly always public records. There are certain exceptions to that. We have the Tracy Baker case from several years ago, where private conversations were going on via the public server, the publicly owned computer system. Those were deemed to not be public records because they were purely private in nature, even though they occurred on the public entity's owned server and equipment. But generally, you probably don't want to do that. The content of the writing, not so much the source, determines whether the document should be disclosed, and that's based on what it says in state statute. The various categories of records, there are all sorts of, it's a really lovely reading. I was going to, and I forgot to bring my statute book so I could read every one of those to you, but lucky you. It's lengthy and it's confusing. There are a lot. If you feel like it, you can read it. It's in Title 24. Exceptions to the Open Meetings Law are narrowly construed. That means there are only a few, and it's pretty much what the statute says. So personnel files are not disclosable. Certain kind of privileged documents, legal memos, for example, that's probably the easiest one to think of. Draft documents, draft legislation, draft policy documents, those are not subject to disclosure under the Open Records Act, which we call CORA, because they're in the process. And one of the things that CORA is concerned about, or at least the legislature was concerned about when it drafted CORA, was it didn't want to chill the exchange, the free exchange of ideas among policymakers, staff, that kind of thing. So they didn't want to have drafts and those kinds of, a lot of just basic memos, thought memos, policy memos. Some of those things are not disclosable either for that very reason. But generally speaking, just assume every email you send, every business writing you make is going to be open to the public. All right? So just something to keep in mind. Quasi-judicial proceedings. Like I said a little bit ago, this you could spend an entire evening, an entire council meeting, and go as long as you want and talk about quasi-judicial, and you'd probably still not finish. Basically, the key takeaway here is that the evidence you rely on when you make a decision in a quasi-judicial proceeding has to be in the record. So that means no ex parte contacts. You can't have other information coming from other sources. No emails from your best friend or your spouse or your kids saying vote this way. It's got to be solely focused on what's in the record. Quasi-judicial proceedings occur when you're going to act basically like a judge, a quasi-judge. as the language says on the slide, determining rights and duties of specific individuals, giving notice and holding hearings, applying laws to facts. That's how you determine whether something is a quasi-judicial proceeding. Interestingly, there are things that look like a quasi-judicial proceeding that are not, because statutorily it's been determined that they are not. Zoning issues are interesting because they are legislative for the purposes of making decisions. They are quasi-judicial for the purposes of judicial review. So a lot of that is found in state statute. Some of it is found in case law. That last little bit is a case law tidbit. As I was saying, judges, including quasi-judges, you can't talk about the case outside of the court. You can't get information from other people. You can't get your opinions. You can't make decisions based on things that you hear outside of that proceeding. You wouldn't want your judge in your traffic violation case to be talking to somebody off the record. For example, maybe it's the police agent who gave you the ticket, and have the judge have an opinion about what occurred, and you haven't even had the opportunity to argue your side of the story. That's just an example. I think you can more or less cover the next couple. Conflict. That's a big one. It's really up to you to decide whether you have a conflict in a particular matter. We will talk about conflicts of interest in just a little bit here, but by and large, if you have heard something outside the course of the hearing, but you know for a fact that that's not going to influence your decision, it's best to state that on the record. Here's what I heard. A constituent told me X. I'm not basing my opinion on that. I will base my opinion solely on what I hear in the record, and I can be completely impartial. If you believe that and that's true, then you can actually participate in that proceeding. Best always to note that on the record, though. Just best practice. Conflicts of interest. Conflicts of interest are not as broad as it might seem. If you stand to gain from a decision that you make, you probably should not participate. Conflicts of interest typically refer to a financial interest. It can be a direct or indirect financial interest, but if you stand to gain financially from a decision that you make, like I said, directly or indirectly, then you shouldn't participate, and if you do, it could constitute a breach of your fiduciary duty, and it is actually subject to criminal action. Partly, and we'll talk about governmental immunity in a moment, but partly because when you do something like that, you're acting really outside the scope of your duties as a city council member, which once you go beyond what you're allowed to do as a city council member, suddenly now you're not acting in the course and scope of your duties. You could be subject to a criminal lawsuit, or you could be subject to a civil lawsuit, and you don't have the protection of governmental immunity or any insurance that the city might have. Number two is important to consider. Always keep in the back of your mind, almost every decision has potential ethical pitfalls. You want to think about, is this going to end up in tomorrow's paper? That's not really a legal thing, but it's a good rule of thumb, because if you keep that in mind, it won't become a legal thing. We don't want to get there. If it occurs, if something happens, and we're allowed to, the city attorney's office will do its best to help you out. Often we'll hire outside counsel in those instances because we don't want there to be an appearance of a conflict. But you just need to keep that in mind. It's a good rule of thumb. If you have a conflict, disclose that conflict. If you think it might be a conflict, you can always ask your city attorney's office. We're there to help you make that decision. We've been called on to analyze those situations in the past, and we'll do it. We'll do it in the future. We'll do it for everybody. So, can't use confidential information for personal gain. Can't accept money or some other benefit. Broncos tickets, for example. I'd die if somebody just gave me Broncos tickets, but it's never happened, so I probably don't have to worry about it. Inducement, reward for official behavior. You do this, quid pro quo, I'll give you a nice suite at the game, right? Engaging in a substantial financial transaction with a subordinate. I'm glad that was written down because it would have been hard for me to get out if it weren't. That might seem a little odd, but that's something that attorneys have to do, something that judges have to deal with. When you engage in a substantial financial transaction with a subordinate, that's a conflict of interest because now you have a subordinate who is beholden to you simply because of that transaction and for no other reason. So you have to be careful about that. Or you act in a way that substantially benefits a business or a client. And this would be more than just you make a decision about, say, a land use decision that benefits the developer who wants to develop, for example. That's a normal everyday thing. But if you have ties to a business, or you have a specific client in whatever area you practice, maybe it's insurance, and that individual is looking for a special permit for an event that would involve service of alcohol, for example. Well, you can't insert yourself into that position for that individual. That would be a conflict of interest. A few more should nots. Don't acquire interest in a business that might be benefited by an official action that just looks bad, smells bad, and could get you in trouble. Don't take a job that would take advantage of your actions while in office. Don't perform an act causing a detriment to a competing business. Just generally speaking, you have to be above board, keep yourselves off the front page, keep those kinds of things in mind. And like I said before, if you ever have a question, you're ever in doubt about whether something is a conflict or not, call Mr. Cox. You can stop by my office too. I'm here every day, and I can help you out with that. Usually, we are not going to have the answer right off the top of our heads, because usually, if you think there might be a conflict, but you're not quite sure, it's probably kind of a unique situation, and we'll have to take a look at statutes and regulations to kind of help you figure that out. But our doors are always open. Leave us a voicemail, send us an email. Governmental immunity. I highlighted within the scope of his or her official duties because that's really important. A government representative's actions, when you're acting in the scope of your official duties, is generally not subject to legal action. We have governmental immunity. Council members have governmental immunity. Staff has governmental immunity. The organization has governmental immunity. The way the statute reads is it shields the city from liability or any government entity for any action that arises in tort or could arise in tort. So tort is not only a delicious pastry, but it is also, in the law, a negligence action, essentially. So one interesting way to think about it is that government entities are not authorized to be negligent in most instances. However, there are a number of instances for which the legislature in its wisdom has decided that governments should waive that immunity. I always think that's kind of an odd way to put it because I'm pretty sure none of us said, yeah, we'll waive that. The legislature did it for us. Thank you very much. Some of those are pretty obvious, things like car accidents, dangerous conditions of public buildings, that kind of thing. Those are instances where governmental immunity is waived. Now, if that doesn't mean any particular individual is typically going to be found, personally at fault, and if they are, typically the city will defend that action and pay any claims associated with that, as long as it's within the course and scope of whether it's the staff or the city council member, the duties of those individuals. One of the things governmental immunity allows for is the early determination of whether immunity exists Typically, there's a hearing. If an instance goes to court, an incident goes to court, we can file a motion to dismiss based on governmental immunity, and that occurs before pretty much anything else in the case would happen. That allows us to get out of a case quickly, and if the plaintiff in an action like that goes through with the hearing, the dismissal hearing, and the city wins that hearing, and it's determined that governmental immunity applies, and the case is dismissed, we get our attorney fees for that. So it's a nice little setup. If we really have governmental immunity, we end up not having to pay if somebody takes us to court for that. It sets a ceiling on awards. So in individual awards are capped at $350,000. Multiple, if there are multiple injuries for one incident, it's capped at $990,000. It also requires that claimants submit a notice, and they have to wait for a response from us before they can even go to court. And 6 months after the incident, after the claim arises, to send us a notice of intent to sue, basically, and then we can wait around for usually up to 3 years to see if they ever file a claim. We can either settle the claim when they file a notice of claim, or we can tell them we don't think that it's actionable, or that we're responsible or liable. I'll tell you, most of the time when we get a notice of claim, we don't settle it at that point, because if we have an issue that was our fault, that we know is our fault, that we know we should pay the claim for, we typically do that long before we ever get a notice of claim. So typically when we get a notice of claim, it's because we've refused to settle that case or that claim early on. Employees, elected officials, appointed officials, volunteers, so employees includes all staff, are immune. If the city is immune under governmental immunity, staff and appointed and elected officials are immune as well, and the city will pay for that defense unless the action is willful and wanton, because willful and wanton takes it out of the scope of your duties. You're going beyond what you should be doing. You're typically doing something that you know you shouldn't be doing. That tends to be what willful and wanton is. Not only are you not entitled to defense, you're not entitled to the city to pay your claim or the claim on that incident. So generally, as long as you're working within the scope of your duties, you should be in pretty good shape, especially city council members. There's not a lot that you can do, honestly, that would rise to the level that would of willful and wanton, such that you wouldn't enjoy governmental immunity. Doesn't mean the city wouldn't be sued over an action. You can take legislative actions that are, generally perfectly legal from your perspective, from what you're doing, but for one reason or another, you have a plaintiff who feels wronged or injured by that action. They can sue. They can still sue, and occasionally city councils do get named in their individual capacity. But we tend to try to get that dismissed out right away. It usually ends up just being the city as the organization, and that's it. That's it. I'm going to sit down for questions because I'm just not used to standing this long without moving around. It's the whole being in one place thing. I'll sit over there. Ask whatever questions you have. Hope you learn something.
Thank you, Mr. Graham. Councillor Harrison.
I just had one particular question that maybe we all need to be reminded of, and that is, when we have an executive session, is there any topic whatsoever that could be discussed outside of an executive session once that's been held?
As far as the discussion items in an executive session, you're not supposed to talk about any of that. Now, what I would say though is, you're going into an executive session. You want to be as specific as possible when you call the executive session. So you might say, something that's near and dear to my heart. We're going to go into executive session to talk about the Rooney Valley, for example. Well, if you come out of the executive session and somebody says, "So what'd you talk about?" and you say, "We talked about the Rooney Valley," well, that's fine. They already know it's about the Rooney Valley. But usually it's going to be more specific than that. Zoning in the Rooney Valley, our intergovernmental agreement with Morrison about the Rooney Valley, those kinds of things. But you don't talk about specifics. So that's really the key.
I want to make sure that all the new people on the council are well aware of how strict that's reinforced, and that we don't want to talk about any specifics outside of an executive session. It usually is a very short amount of time when it goes from executive session to a particular item on the agenda, which there is public comment and we can talk about everything. So it's really important that we make sure that we keep executive session truly private and within council.
Yeah, I would agree, and I think you have to think about the reasons for executive session. One of which is negotiation. If you are negotiating maybe a property purchase, for example, it's an easy one. And then after executive session, everybody goes out and blabs. Oh yeah, they offer. We offered them $1 million, but we agreed that we'd probably pay $3 million for that property. Well, guess what? You're going to pay $3 million for that property. So that's just an example of, just practically speaking, why you don't want to talk about things outside of an executive session, and things like legal advice outside of an executive session. If you're given legal advice by your city attorney, one thing I guess we haven't covered specifically is that a city attorney's legal advice, it's privileged, right? It's privileged to the body. So no one city council member or two city council members, no number of city council members has the legal authority to divulge or to break that privilege. Right? You have to vote as a body to break the privilege, because the privilege is with the body as a whole, right? And if you're discussing what you found out from your attorney, in an executive session, and maybe there's a lawsuit going on, maybe there's a potential lawsuit, something like that. Well, now whoever's suing the city, and keep in mind, people are suing the city. Now the other side might have some of that information to know what you're thinking. So those are examples of why it's not only is it prohibited, but it's not a good idea.
Well, I think a lot of our constituents are really upset with us because of the fact that we don't share with them everything that's discussed during executive session. And I feel like they think there's a deal being made behind closed doors. And it's not that at all. It is the nature of the discussion itself needs to be held private until such time that it comes before the whole public. So I think that that's an important thing. One other thing that I wanted to talk about is conflict of interest. If we can describe that just a little bit more. And I wrote down 3 different notes in my ward, in my neighborhood, and in properties that are in my adjacent. Can you kind of hit what is a we talked about business, but as counselors, are we, when there's something in our ward, do we have a conflict of interest? I don't think we do, but could you address that?
Well, generally, no. If what you're saying is there's a business that wants to go into your ward, what really is the conflict is if you're going to typically gain personally, gain financially, if your immediate family is going to gain financially from a decision that you make, based on that, or if you're somehow inserting yourself in the process beyond the city council decision-making process. So, for example, I'm trying to think. Somebody needs, a utility easement through their property or for their property, and you go to Public Works and you try to pressure, the Public Works director to get that done. That could be considered a conflict of interest because you're inserting yourself into that process when you shouldn't be. Mr. Cox?
Well, I just wanted to make a point, too, that when Greg talked briefly about quasi-judicial actions, there are restrictions on what you can do because of the nature of the action as a semi-judicial proceeding. Ex parte context is the one he mentioned, so you're talking to somebody outside of the hearing and they share their opinions on the matter, hoping to sway your vote, and you have to tell them, I may not be able to vote if you disqualify me because we should be talking about this at the hearing and not outside the hearing. That's the most common limitation on, or the most commonly talked about limitation on quasi-judicial proceedings. What you're talking about, I think, to some degree, is either bias or prejudgment, which are parts of that same So it's not necessarily a financial conflict at all. It's that it's in your neighborhood. You've lived on this street for 25 years, and it's the house down the street that's going to be converted into something else. You have an interest in it that might be different from someone outside of the ward or the neighborhood, but it doesn't necessarily disqualify you if it's at the level where you simply cannot act fairly and objectively because of your proximity to that. And the same thing goes for bias, which is generally that you have some either animosity or some friendship with an applicant or something, and that bias is going to skew you from being able to talk about it objectively. Those are the kinds of things that happen in your neighborhood, whereas conflicts of interest is used more broadly, but really only talks about financial conflicts where you're going to make money off of a decision that you vote on.
Thank you.
Councilor Bida.
Thank you, Mayor. A couple of questions. First of all, you mentioned the Costilla case. Do you happen to know the other parties in that? I'd kind of like to look it up and read that case. Do you happen to know? I'm probably putting you on the spot. I'm sorry.
I used to.
Okay, that's all right.
I can't think of it now, but it's probably one of the only Costilla County cases out there.
I think, Councilor, if you do look up the Costilla County Board of County Commissioners, that was one of the parties to the case. I don't remember the plaintiff who challenged the ability of the commissioners to do that, but I think if you Google Costilla County, you'll get on the right track. And
about what year was it?
It's probably, 10 years ago now, I'd say?
Yeah, something
maybe a
like
little
that.
longer. And we'd be happy to get a copy of the case for you so you don't have to.
Okay, I could probably find it with that. Thank you. A couple of other things. Emails. You talked about open meeting and emails. It seems like emails can be a real kind of a trap for the unwary. Can you go into that a little bit more specifically on emails and when they might or would constitute an open record violation?
Well, it'd be more of an open meeting violation.
Open meeting, I meant.
And so what you're not allowed to do is hold a meeting via email. And so, if you're, and there's a little bit of gray area because the courts have not specifically addressed that question. What does it take? What are all the elements to create a meeting? If you're having a meeting by email, but basically, if more than three or more council members, I should say, are discussing public business and they're discussing it back and forth via email, that's probably an open meetings violation. If a council member is just sharing a bit of information with the rest of the council, may not be an open meetings violation. It kind of there's an element of the quasi-judicial versus the legislative process that's involved in this as well. Because, for example, you can talk to your neighbors about ordinances you're going to pass. That's legislative. That's not quasi-judicial. There's no gag order on that. You can talk to your constituents about legislation you're going to pass. So you can have conversations with your fellow council members as well. It's just that when that kind of discussion occurs via email and it's a discussion among three or more council members regarding the substance of city business, that's probably an open meetings violation.
So basically, rule of thumb, as I'm understanding you to be safe, would be limit your emails to other councilors to one at a time if there's any chance that may be looked at as involving city business.
Yes, and I think it's also important to keep in mind, serial emails. So you email one council member, they get back to you. You email another council member, that person gets back to you. Do this with all 10 other council members, and maybe you do that a few times. And thought, well, at some point that's going to look an awful lot like a meeting.
And so in that line, then, if I send an email to one counselor and then they send it to another counselor, at that point, that could be a problem. So the best bet would be not to forward emails from one counselor to another counselor, correct?
I would agree that the best rule of thumb, I would say, would be to not forward those emails. But it depends also on the content of the email.
Yeah, I get it.
So if you're talking about the aesthetics of a current structure, I really don't like the color of that building on,
I could argue be considered, I could see somebody arguing that as city business.
Well, I
talking
could,
about a city building.
Well, I don't mean a city building, just any building in general. Even a city building, though, that wouldn't necessarily rise to the level of discussing city business, because if you don't have anything that's potentially coming before you those comments address, then it wouldn't necessarily be city business. So you have to have that. There is a content aspect of it as well.
Counselor, if I just may, this as an example of how the legislature hasn't really caught up with 21st century yet. The open meetings law does talk about a meeting can be in person or by phone or electronically, and email is identified as a means of communication. But what they haven't done is told us that one message you send out to 2 or more of your colleagues is a meeting, or you send it to one person and that person sends it to 2 others, and that's a meeting, or it comes back to you with an answer to your first request. We don't know where that line is, so what we try to advise is try to avoid using email to communicate with each other about anything that is official. If you're saying, I want everybody to know I'm stuck in a snowstorm, I'm going to be late, that's one thing. But if it's on the merits of an item that's likely to come before you or has come before you, it's best to just save that conversation for the public hearing process.
Got it. Thank you. Next question. So if I understood you talking about the executive sessions, let's say a motion for executive session, and you said we follow the ordinance 2.51. So if we're crafting a motion for executive session and we want to go into executive session, we're safe in relying on 2.51 instead of the statutory requirements. Is that my understanding?
Well, actually, typically what we do is we cite both our own charter and state statute. And the clerk's office are the folks who, they work with the city attorneys and whoever is calling the executive session, so that we get that language just right. And we should know what the motion is before it's ever made. It should be very rare that when a council goes into executive session without it already being on the agenda. So we'll have prepared that ahead of time. But typically, yes, we're going to cite both the charter and state statute.
Okay. And if it was something that we were doing, let's say, that came up, here on the dais, you would also help us craft the motion so that we met the statutory and the ordinance requirements then?
Yes, absolutely. We might have to take a quick recess and go find our statute books, but yes, we would help you do that, certainly.
And then on quasi-judicial proceedings, again, as to emails, those emails can be troublesome, I think. So we may not have any control over emails that we may receive from constituents on a quasi-judicial proceeding. How do we handle that? Obviously we can ignore them. Do we still disclose those prior to the hearing that I got 50 emails on this issue?
It's funny you should mention that number, Counselor, because there's a case from the Court of Appeals from several months ago. I did a presentation on it with a CLE, a continuing legal education program, just a week ago, on the impact of that case, and it involved a controversial rezoning case in the city of Denver, where one of the council members received approximately 50 emails for and against the proposal, and did not disclose those emails to his or her colleagues. I'll try to keep it generic for this discussion, but the council member did not share those emails until after the public hearing had been underway. And when the rezoning was approved, and that councilor had voted against the approval but still had not disclosed that information, one of the things that opponents of the proposal of the project did was they filed a lawsuit, a challenge, an appeal, and argued that there was a violation because of the ex parte context there, because these emails had been provided, and the Denver City Attorney's Office, like ours, always recommends if you get something, whether it's an email form or a phone call or whatever, that you share it with your colleagues by making a disclosure, asking the mayor ahead of time for a floor at the beginning of the discussion, and making that disclosure. And we're happy to help you craft the language of that disclosure so that it's comfortable for you and fits the circumstances. But you make that disclosure so that at least there's something on the record saying, now you've all heard what was said to me in private outside this hearing. Of course, summarizing 50 emails would not be easy, but there was no effort to do that. And unfortunately, I think the court set a new rule in Colorado. It's something that we'll talk to you about in greater detail. But it says in order for those emails to cause a reversal of what happened in the appeal, there must be substantial prejudice. It's not enough to show that there was this contact. There's a presumption that all of you are acting with integrity and honesty, and to overcome that presumption, it has to be shown that there's substantial prejudice. Well, when you get to your first quasi-judicial case, you're going to think about how would anybody prove that there was prejudice? Did I change my mind because of what I read in that email? If I read it to the others, did somebody over there change her mind about it? It's very difficult to meet that standard of showing substantial prejudice, and we still would recommend that in the interest of due process for all involved, that you do get that information out in front of your colleagues so that everybody has the benefit of the same information.
Which, Counselor, then, if I'm understanding you to say, then I'm going to have to go read those emails in order to disclose what I got, even though I'd rather not read them at all. But I can't just forward them to everybody because then I'm going to be violating the.
Well, you don't know what's in them, and on the one hand, you might just say, "I got this. I'm just forwarding it on," so everybody has the same information, and then you read them in the course of the, as part of your packet when everybody else gets it. That's one way to deal with that.
Yeah.
Okay. Let's see. I think I had one other one. Nope, that's it. Thank you. You've been very helpful.
And Councilor Bita, that's a great question, and what we can do when you start getting into land use cases is forward those to either the clerk or the director and ask that they be put as part of the official record. So that way everybody is sending it to one place, and those are accumulated and then sent out to the whole council together. Yep, absolutely. Councilor Roybal?
Thank you, Mayor. You kind of touched on the CORA requests. I wanted to get some clarification from you. When they do a CORA request, granted we have a city system, we have iPads here, and we communicate back and forth. Can you please touch on when you ask for a CORA request for certain things, can you kind of talk a little bit about what's allowed on the CORA request, what's redacted from emails, or what's privileged information? Can you kind of touch bases on that for us?
Well, it really depends on what the request is for. Like I mentioned earlier, the statute has a number of instances where it discusses what can be released and what cannot be released. Some things may be released unless it's determined to be in the best interest of the public not to release those.
But who would make the judge? Who would make that decision?
It's typically the city attorney's office is very involved in those decisions. Partly because if someone says, I want the personnel file for every member of the city staff, we're not going to allow that. There are open records requests that fall under the what are called criminal justice records, and they have a different set of standards, and so it's up to our police legal advisor in most of those instances to determine whether the request can be honored. It's not uncommon for an open records request to include items that are not disclosable and items that are disclosable.
Now, the question that I have, with the new technologies moving forward, does our IT staff just go into the emails and bring them out instead of us trying to forward them forward?
That's correct. So if we get a request for emails for between Councilor Roybal and Councilor Vincent, that just goes right to IT, and they do their keyword search. They find those emails, and then they just produce them to. Typically, it goes to the clerk's office, city attorney's office. There can be privileged materials, in some of those emails. So we end up spending a lot of time, actually, Mr. Cox and I, on reviewing open records, the responses to open records requests to determine how much is disclosable.
So at the time, it'll all end up at the city clerk's office, and she forwards them over to the requester.
That yes, at the end of the process, once all those determinations have been made, city clerk's office provides that information.
And how long does it usually take to go through the process after the request?
It depends on how voluminous the request is. We will get requests for, records that are, there may be hundreds, even literally thousands of hard copies of records. We've had requests that have generated, tens of thousands of emails. So we typically try to work with the clerk's office. Typically tries to work with the requester to let them know, okay, we have 65,000 emails that could be responsive to this request, and we're going to have to go through all of them. Do you want to narrow that request a little bit, because we're going to have to charge you for all that time?
And the charge is pretty much set by
statute.
By statute.
Mm-hmm.
Okay.
Mm-hmm.
Okay. Thank you. That's all I have.
Councilor Gutwein?
Thank you. That presentation was very helpful. Thank you. And I also liked having the quasi-judicial conversation with our community, because I think that's one of the things that we get the most question about, and it can be really difficult to not be able to talk about land use issues with our community, because it really impacts them. So I think it's helpful to all be on the same page. My question is just about executive sessions. I know they're recorded. Once they are finished and recorded, are they subject to Cora and open records?
Generally, no. You have to get a court to require that release.
Okay. So the purpose of then recording them is just so that if there was a court case, then we would have.
Yeah, I think there are probably, and certainly Mr. Cox can jump in here. I think there are two real main purposes. One is, sometimes we do need, it may be for a perfectly good reason, it may be for a more nefarious purpose, but sometimes we need to go back and listen to those recordings to determine what was discussed. And generally, and that's internally, and then externally, if anyone wants to claim that that the city or the government body that went into executive session did so either illegally or discussed items that were beyond the scope of the announced executive session, or made decisions in the executive session, that those records are available for a period of time.
Great, thank you.
Councilor Abel?
There's a specific shelf life for those recordings, is there not?
For executive sessions?
Yes.
It's 90 days.
Thank you. And that gives 90 days an action to be filed?
That's correct.
And on the content of those things?
That is correct.
All right. Well, thank you for that presentation. I think it's nice also for us to be able to archive this for the community to have a little 101 as well. Just want to add.
I signed a release for that, Mayor, so might have to talk about that.
That's why you make the big bucks. Couple things though, just to clarify as well. If you do have, if you think you may be in a place with two or more council members, then it is, always err on the side of caution and reach out to Margie, and she'll get it posted. And if you're curious about what are the deadlines for postings? At 3 days?
It's actually only 24 hours, okay. But because of the way our website is set up and we now publish those on the website only pushes out the content like every 2 or 4 or 6 hours. So we always ask for as much time as possible.
Okay. And then I would also say, if you have an email that you would like to share, for instance, when we were doing the council committees, I had put on there, please do not reply to all. So, if you feel like you are in a gray area, you might not know, just throw that on the bottom. Just err on the side of caution. And then lastly, I would say in the olden days, when a request would come in, you would just dig through your own files. And so now our system is, even if an email is deleted, it's found for that time frame of recovery, which is like 2 years maybe. Is that accurate? So 2 years, and then that is automatically pulled. So anything else? All right. Thank you. Appreciate that. Clerk, please read item 5.
Item 5, Resolution 2017-44, appointing the Mayor Pro Tem of the City Council of the City of Lakewood.
All right. So I will now ask for a motion on Resolution 44.
I'd like to offer a motion from the dais.
Okay.
Get past that. I move to table the motions to elect council officers until, that's plural motions, until after the adoption of the new policies and procedures manual language that is city charter compliant. Further, that current city council officers remain in office until after the city council's decision on the new policies and procedures manual language.
Okay, we have a motion. Is there a second?
I'll second that.
Okay, we have a motion and a second to postpone. Does it need to be a date certain or just...
It'd be nice to have a date certain for the policies and procedures manual, but I think you have an event that would trigger the need for the new appointments, as I heard the motion, that once the policies and procedures manual is adopted, then in accordance with those policies, the motions would be brought back.
Sure. May I elaborate on the reason?
So there's a motion and a second, and yes, you may.
The current language requires the mayor to nominate and city council to ratify. Ratify means to approve. The city charter says on that mayor, Article 2, Item 2.4, Mayor Pro Tem. A Mayor Pro Tem shall be selected by the City Council. To select from City Council, we have to have a choice. Under the language that has been used for a number of years, there is no choice. Apparently sometime in the past, the language of City Council, a Mayor Pro Tem shall be selected by the City Council, evolved into a Mayor Pro Tem shall be selected by the Mayor and City Council must approve. Whether that was done through ignorance of the Charter, or whether it was done to skirt the Charter is not relevant. It was done, and it does not jive with the purpose and stated meaning of Section 2.4 of the City Charter. The new Policies and Procedures Manual has been hammered out, the language been hammered out through 5 council workshops. When we hit this particular item, the consensus, the majority consensus, which involves the majority of us sitting here, arrived at language that says, if you'll pardon me a second, all of this is electronic, here we go. 1 member of City Council is chosen each year to serve as Mayor Pro Tem. The Mayor Pro Tem is nominated by the Mayor, presented to City Council for a vote, before which open nominations from the floor will be accepted. That is compliant with the Charter. Our current language is not. There is a provision in Robert's Rules of Order, 3.9, ratify. it says that a body cannot ratify anything done in violation of the laws of the state or its own constitution or bylaws. This is our bylaw, this is our constitution, and the charter language that's in there now is not compliant with the charter. The upshot of it is that we would be keeping our president and mayor pro tem as they exist now until this is done. There is a requirement, I believe, that the mayor cited about having to do this in December, but the last 2 years we have appointed officers on January 4th and January 11th. So the officers we have now haven't served a full year. I see no harm in holding off until we have language that will clarify the process and make it compliant with our charter. It also would mean I had hopes of being the last president of Lakewood City Council because the new charter language apparently proposes that we no longer have a president, but being the last and shortest serving president of the council was kind of on my mind, but I'm willing to give that up in order to have a process that upholds the provisions of our charter. Thank you.
Thank you. So I would just add, when reading the charter, you have to actually read the whole provision.
Please do.
Sir?
Please do.
2.2, Mayor Pro Tem. Mayor Pro Tem shall be selected by the City Council from among its members for a term and in a manner determined by the City Council. So that's the second part that must be read. And in a manner speaks to either the newly adopted version that may come under the new policies and procedures or the current one that's in place under our current policies and procedures. So I think when we look at the charter, we have to actually read the whole thing and not just that first sentence.
But we
Counselor
do,
Franks.
and there's nothing in the charter
Counselor
that
Abel, you do
allows,
not have the floor.
there's nothing
Counselor
in the
Franks.
charter that allows the council to override the
You're
vote
out of order,
the people,
sir.
the vote of the people
Charlie, you are out of order.
resulted in the charter.
You are out of order, sir. You do not have the floor. Counselor Franks.
Thanks, Mayor Paul. I did want to kind of bring a little bit of more context to this. So when I joined council a couple years ago, I was not even aware that the policies and procedures manual existed. Actually, a constituent had to bring my attention to that. And immediately upon reading it, there were several things that concerned me. I'm basically, since I believe so strongly in representative government and in democracy, for me, I always am cautious about any centralization of power or in appointments. I just tend to be somewhat cautious about those. And so I immediately made it known to the entire body at that time that I wanted to look at revisiting the council's policies and procedures, which, to be honestly with all of you, is currently a very poorly written document that contains all types of editorialized comment that was wholly inappropriate for an ordinance. And so we did begin a lot later than I would have liked, but we certainly did get underway and start working through that. I wanted to kind of bring up a couple things where I do agree with the mayor that we certainly always want to read the entire reading of that, but I read it differently. I still read that it should be selected by the city council, that we select, but the manner in which we choose that should be with us. Where I start to disagree is that another former council board could come in and kind of control what this one does. Basically, they've kind of taken the charter, they've narrowed it, they've changed it, and then now they're enforcing a kind of rules upon us. And I expressed at that time, and also during the study sessions and working sessions that we had, that I think what happened with the 2009 and 2010 ordinance was it created an adversarial rather than a collaborative process by its very nature, if you think about it, if I were to nominate someone and then this next step was for a group of people to ratify, people who maybe wanted to throw their name in that hat, they have to take an adversarial position in order to challenge that. So in my view, it set up an adversarial process, which I again think harms the process rather than supports the process. The other thing I wanted to switch to, just to maybe clarify a point, was, and we actually had a mediator come help us through that council's policies and procedures process, because we understood that we were going to be changing some things that had been in place for a while, or talking at least through those. And from the notes that were taken, I just wanted to correct something that Councilor Abel said. When we got to this discussion about the council, some of the council pieces, there wasn't consensus on many of those. There was kind of a decision that they would let the committee kind of go back and see if they could craft language that was that the rest of the group felt was appropriate. So there was many cases where we didn't achieve consensus thinking, but we took all of that input and we have good notes to refer to about kind of what were the options, what were the ideas, and then we could take that away to craft language and bring that back before folks. So I just wanted to kind of make sure people were aware that we didn't kind of come away with rubber stamps or, consensus thinking on everything. The other thing that I really wanted to talk about is, I think that for me, the democratic process is what's so important, and that's why, again, I don't really tend to like appointments. I like when a bunch of folks can come together and say 3 or 4 of us up here felt that we were had the skills, the time for that we could throw it in there and we could collaborate our way through that. I just see that as a much more positive experience, where I could say, and in this case I'm not saying that I want the position because I don't have the bandwidth at this point, but it just makes it more collaborative, where folks are saying, hey, here's why I want to do it, and here are my skills, here's the things that I've done that I think prepares me for that. And then the next person takes their chance, and it really becomes more collaborative than adversarial. I also think rotating these positions around gives us diversity of people and good ideas. And so I really wanted just to weigh in that I think this delay until the council's policies and procedures is a good thing, even though I am not in agreement that all of the language is exactly where I want it to be, but that's part of how these things go. They're a collaboration, and I still want to work through that and get to the point where currently the language we have proposed is 1 member of City Council is chosen each year to serve as Mayor Pro Tem. The Mayor Pro Tem is nominated by the Mayor, presented to the City Council for a vote, before which open nominations from the floor will be accepted, which is that collaboration piece. This will occur at the first regular meeting of a council meeting in January and requires a majority vote. So while that's not the exact language I would have wanted, I just kind of want you to know kind of where that language was evolving. Thank you.
Thank you. Councilor Gutwein.
Thank you.
On the motion.
Yes. So, Mr. Cox, I was wondering if you could provide some insight if our current policies and procedures is not compliant with the charter.
Well, policies and procedures like ordinances are used, and sometimes resolutions are used to often elaborate on what's in the charter. The charter kind of sets the framework. These are our general policies and principles that we want to follow. And then there needs to be some meat on the bones, and that can be done through the code, through a freestanding ordinance or a resolution, or in this case, the policies and procedures is often the place where at some point in history, and a lot of this language predates the 09-10 version, is just accumulated over time. That's the place where we lay out how we actually go about doing it. So in this case, where the charter has slightly different language in saying the mayor pro tem shall be selected by the city council from among its members versus nominated by the mayor, then you have that in a manner determined by council. So, I think that gives you some leeway, as Councilor Franks was saying. You might want a more collaborative process. Well, that's going to depend on what you as a group or the people working on the policies and procedures manual decide. At some point in history, some group decided that it would be a nomination by the mayor and a ratification by the council. There are other options, and the manner determined by the council it has some flexibility involved. So I think it's difficult to say whether there's a conflict now, because there's a manner described for that appointment in the policies and procedures as invited by the charter. Now we've got a new manual coming out with some different language that hasn't quite been resolved. You didn't ask, but my only concern on this is it has taken a long time to get the policies and procedures manual into the position it's in now, and it had become something much more than just these are the policies that we're going to follow. It was an orientation manual for council members. Over the years, lots of things had been added that were really not policies, and part of the difficulty in this process was culling those out and focusing on policy matters. It's taken that long, and we know there are still some loose ends, some language needs to be worked out, and we don't have a firm end date. We have an agenda that identifies a time for talking about that, but it could take a while longer than that. That's one risk of waiting for that to happen.
So I just want to make sure, as it says in the charter, that a mayor pro tem shall be selected by the city council from amongst its members for a term and in a manner determined by the city council. And for the last 2 years, we've followed our current policies and procedures, which say we have 1 year, and then we're nominated, and then ratified. So that is a legal way to determine our mayor pro tem, is what I'm asking.
I think the position is that the policies and procedures manual dictates that process as the manner determined by the city council as set forth in the charter, and it's been used to this point, and that's the currently effective policy and procedures manual.
Okay. So I know that there are some people who would like to change our current policies and procedures, and we've all participated in that process. I think it's going really well. And slowly, as Mr. Cox just mentioned. And so it's really hard to say when we'll be finished going through this process, what the terms are going to be, and then we will have gone probably past a year for those terms. And then I also just would like to point out that we have used this process for the last 2 years and significantly longer than that. And so it feels, I'm not sure why we would change it now instead of using the process that is currently adopted. Thank you.
Councilor Abel to the motion.
Yes. Just because we have been doing something for a while doesn't mean that it is compliant with the charter. 2 years ago, when you and I took our oaths of office, we took an oath that was not charter compliant. We violated the charter with that oath. We came back weeks later and repeated the oath to make sure we had the one that is correct by charter. Just because an action has been in, or a process has been in place for years, doesn't mean it comports with the charter. We have done a number of things that are outside the charter, and in the last couple of years there have been some issues, some proposals made that would have been charter violations had they not been caught and changed before we approved the ordinances. So the language of the charter stands. I don't think that the charter was approved by the voters of the city of Lakewood. And when they said that the pro tem shall be selected by council, I don't think they meant that the manner determined by council would be allowed to shirk that requirement. It's very clear what is stated here, and I think we should live by it. I think also you point out that the current president and pro tem would have a term longer than a year. If we change it tonight, they have a term that lasted less than a year. So we have those variables that are going to happen anyway. And I believe, Mr. Cox, we could vote to put the policies and procedures manual on a fast track, have a study session to wrap up the remaining issues, and to take the ideas of the new council members and mold those in, have a first reading a week later and a second reading 2 weeks later. So I think we can, in some ways, limit the time gap by expediting the process. Thank you.
Councilor Skilling.
Thank you, Mayor. I was just wondering, we keep talking about the 1 year. I'm wondering if that's charter, if that's policies and procedures, because I've been scanning through this iPad here and I can't find where it says 1 year. So it seems to me, I think that Councilor Franks has suggested that everyone just stay put in their positions. And if we were to do that, whether it's January, March, next September, that doesn't seem to violate the charter unless I'm missing something.
The charter does not specify beyond what we've heard up till now that a mayor pro tem shall be selected from among its members in a manner determined by the city council, and then it talks about the duties of the mayor pro tem filling in for the mayor. Where the policies and procedures manual addresses it is in the heading under the heading city council officers. Again, the language we've been talking about, the mayor pro tem is chosen by the mayor and the choice is ratified by the city council at the first regular meeting after a study session in December. And then it says the council president is nominated and voted on by members of the council and assumes the responsibility at the same time as the mayor pro tem, and then each serves for a 1 year period. So it is in the policy manual. That has been the practice for a long time. That is potentially subject to change as you go through the policies and procedures discussion, and I don't know that there's been any proposal to change the 1 year period. But
if it takes through January or February to get these new procedures in place, leaving the officers as they are so that those positions are filled does not violate the charter, correct?
I would agree. Sure.
Councilor Bida.
Thank you, Mayor. Just a question, and I'm not sure who to address this to, but realistically, how long would it take us to address policies and procedures if we made that a priority, fast track? How long are we looking at?
So, I mean, we're scheduled, I think, to see that again in February. It still needs to go through a whole legal review, so we'd be looking at February or March.
Can we isolate out the portion that relates to the appointment of Mayor Pro Tem and deal with that quicker as a council?
It's a good question, Councilor. I've been thinking about that because I know when the process started of rewriting the manual, there was a lot of talk about we really want to focus on these 3 or 4 things, get these things straightened out. The rest might just need some cleanup. I think the project turned into something more than that, but I believe there's been talk of adopting it sort of section by section. I think the preference was to keep it all together in one manual, but as a way of getting through the processes, I'd say there's nothing unlawful about adopting it in sections. And theoretically, the council could decide to have a session on one item and get agreement on that language and act on it. I don't know how long that might take, but that's one option.
Any reason we couldn't have that done in January?
So we're getting a little bit off track on the motion. I appreciate where that's going.
Well, it's just a question.
Yeah, no, absolutely. I appreciate that. I don't have an answer for that. And maybe while we continue, there's some more folks who have this lit up to deal with the motion that's on the floor. Okay. Yep. Thank you. Councilor Franks.
Thanks, Mayor Paul. I appreciate everybody's questions here. That's bringing a lot to light. I did want to reiterate that it has been, it has been 2 years plus. This is not something that was brought up late in the game. This is something I brought up in the very first meeting that I attended. So I really want folks out in the audience to know that this is not just some last-minute thing. This is literally the first meeting I went to where I said this is a problem, and we're here now going to be more than 2+ years later. So if you sense some frustration with me, that's just because there is a lot of frustration. Where I do want to add the good comments is I think we took a very poorly crafted document, and with the help of Nanette Nealon and others, trimmed that down to just what needs to be in there. There was a lot of stuff that had no business being in there. We cleaned up language. We changed the formatting. It's easy to read. I personally don't see a massive amount of legal review given how limited we really brought this back into. Also, I do wanted to comment that as the committee chair for this drafting committee, along with Mayor Paul and Councilor Abel, I think we did some really good work. I mean, it's not none of us got everything we wanted. I mean, that's just part of how these things go. But I think we did some really good work. I think we are really close. I would like to look at it holistically, but if that's something that's going to push out the timeline, certainly this one piece could be pulled out and turn this from being an adversarial situation into being a positive collaboration where we can, nominate from the dais. I think all of those things are really important, and I see no harm in actually delaying this until that section or the entire manual is completed.
Councillor Vincent?
So do we have two things going on here? One is we have to decide on the motion, and then if it passes, then we have to decide on whether we pull just that piece out of the policy and procedure, and then third, we'd have to set a date?
Well, right now you have the motion in front of you, and that needs to be the focus. There are issues to be decided if the motion, after the vote on the motion, one of them would be how to go about adopting the manual and what you want that language to say.
So that would be kind of the track that we would want to go. Right. Thank you.
Councilor Gutwein?
Well, thank you. I just wanted to say I don't think that something that just because we've done something for a while makes it compliant with the charter. That was why my first question was, is our policies and procedures compliant with the charter, which the answer was yes. And then the second thing I wanted to say is just about the adversarial and collaborative conversation. So since I've been on council, we have had 2 times that we have selected a mayor pro tem and a council president. And the first time was after a really competitive election and after the election for mayor. And our mayor nominated his former opponent, Councilor Johnson, to be his first mayor pro tem. And we unanimously supported Councilor Johnson. We unanimously supported Shakti. Then the following year, we unanimously supported Karen Harrison for mayor pro tem and unanimously supported Councilor Roybal as councilor president. And I think that that is an incredibly collaborative process. And it's a tradition, frankly, that I'm really proud of because I think it sends a really powerful message to our community, which is after a divisive, competitive election, we're going to come back together and we're going to work together and we're going to put aside everything that happened for the sake of our community and respect each other's voice. And I'm really proud that I was very proud to support all of those people, as I'm sure everyone else who is up here and had the chance to do that was proud to do as well. And so I think it is a collaborative process to support one another in the way that we have. Thank you.
All right, so we have a motion and a second to postpone this indefinitely. I would say that, a mayor pro tem, especially in things that I have coming up, is important. And I haven't had that conversation with Councilor Harrison to see if she can continue her time. The idea that somehow if we change our language, we're back in line with the charter is just a fallacy. It's not actually true. We're in line with the charter both ways. And the fact of the matter is there was never an issue when I nominated Councilor Johnson for this role. So if it wants to be political, we can be political, but I would just urge a no vote on this motion and just let the chips fall where they may and we'll see who we have for council officers instead of trying to tiptoe around the real deal that's going on behind the scenes. So with that, please cast your votes. Did everybody vote? Who are we missing? Okay. Somebody's not locked.
Councilman Beda, you'll need to place your vote.
There you go. All right, so that fails 5-5. The nays being Paul, LeBeer, Gutwein, Harrison, and Vincent. Councilor Franks.
Sorry, I just felt compelled to add. For me, this isn't political. I know some folks are trying to make it into that. Again, day one had this, so I'm not going to take that label. I own generally what I do up here, and that is not fair to label it as being political. When the very first meeting I went to, I brought this issue up, so I just felt compelled to be able to say that. Thank you.
Councilor LeBeer.
Yeah, I just wanted to explain that I voted no on the motion because this is the first I'm hearing of it, or anything about not supporting voting on the mayor pro tem. And I've been here for 3 weeks now, and the first I'm hearing about is on the dais the day we're supposed to vote on something. And I just think changing horses midstream is a bad idea, so that's why I voted no.
Okay. So the original motion is still on the table, motion 44. Actually, we'd have nobody's read it into the record. So I need a motion for item 44.
Okay, Mayor. I vote for the adoption of Resolution 17-44.
Second.
All right, there's a motion and a second for item -44, and that would be to nominate Councilmember Gutwein to serve in the role as Mayor Pro Tem. Any discussion? Councilor Harrison.
Having served as Mayor Pro Tem for the last year, one of the things that I would say is that this is an interesting position to be in. You would think that it has a whole lot of wonderful power, but it doesn't. And your payroll doesn't double or anything like that. What you're asked to do as Mayor Pro Tem is attend meetings anytime the mayor cannot. Most of those are speaking engagements. There are other committee assignments that as Mayor Pro Tem, potentially the new Mayor Pro Tem would be asked to attend. But in terms of running the council, the Mayor Pro Tem, other than the nights that the mayor may not be here, sitting in this chair right here, and that needs to run the meeting, it's simply, think of it like vice president in another organization that you might be in. There's not a tremendous amount of power that goes along with it. I want you to hear that so that when we get ready to take this vote, you will see that it is political. This is being used as a way to gain control. And I don't believe that that's what this position is meant to do. So I say that out loud. And I'm not talking about Dana. Thank you. Dana would serve very well in this position.
Councilor Beda.
Thank you, Mayor. Mayor and Council, ladies and gentlemen, in looking this position over, the position of Mayor Pro Tem is a leadership position first and foremost. It requires extensive leadership experience. Now, it's no secret in the past that this council has been sharply divided on some very important issues. We know that. In order to pull this council together, it's going to require a leader with skill, I believe, and diplomacy to bring together the various factions of this council so that we can move forward in the direction that we need to go. It's going to take someone who is not merely an ally of the mayor, but rather someone that's independent and with a different perspective, different approach, someone who will balance the ideas and approaches of our mayor with the positions of some of our other councilors so that we can pull together and move forward. I know that Councilor Dana Gutwein is a very bright, hardworking, dedicated, and accomplished young woman. I think she has a very promising future in a leadership role in this council. However, she only has 2 years on council, and in fairness, she has not had the time or the experience to develop the leadership skills and the just the judgment and leadership that's required that we need today, right now, in this council. She is also from the same ward as the current Mayor Pro Tem, Ward 5. She has a history of siding with the mayor on important issues. This history does not lend itself to bringing in the different factions together that we need. We do have other councilors on council who are qualified and do possess the extensive leadership skills that this position requires, and they are willing to serve. For these reasons, I'm going to vote no on her nomination as Mayor Pro Tem.
Thank you. Councilor Skilling.
Thank you, Mayor. I'm going to push back against the idea that somehow voting yes or no on a committee position is strictly political. I think that those that know me and those that know Barb, and let me start by saying I echo exactly what Councilor Franks elaborated on, that the current process as it is now is not only out of line with the charter, but it also creates a situation where some folks that may want that position are unable to even throw their hats in the ring and even be considered by this council, by the public. And that's, to me, an undemocratic way to go about things. And it could very well be that Councilor Gutwein becomes the Mayor Pro Tem, but I would like to see it in a truly collaborative process. And collaboration means, I mean, and I don't hold it against you, Mayor, but nobody called me and said, hey, I'm going to nominate Councilor Gutwein to be Pro Tem, and that's a decision that you had made, and I don't, that's in accordance with, I suppose, the existing procedures. But collaboration means that everybody has a chance to take that position, to discuss the qualities, and Councilor B to just discuss some of those. And I'm not agreeing or disagreeing either way on that stuff, but I do want to echo what Councilor Franks had said. And let me assure you, this is not, from where I sit, this isn't political. I don't belong to any factions. It's just about following what the charter says, that council will have a chance to select the people. And if there's another person who wants that position, why on earth would we not want them to at least state their position and vote on them? I don't see why that would be a bad thing. I think that that's actually the proper way to go about it. So I just wanted to push back a little bit on the political aspect. Maybe in the past there have been councils and council members that have been political, but I think those that know me know that I'm not interested in being political or rehashing those factions, whatever you want to call them, of the past. And in fact, I've been up here talking about how I want to move things along and pass a lot of good, solid legislation for my ward and for the city of Lakewood. And the only way we're going to do that is if we can collaborate and get past this stuff and get to the stuff that really matters to the people out here. So I just wanted to add that. Thank you.
Councilor Abel.
Thank you. I, too, disagree with the idea that this is political. My concern is for the integrity of our charter. I am disappointed that someone would say it was an effort to gain control of what? It could just as easily be seen as an effort to retain control. So my concern is for the integrity of the process. I'm a process person. One of the reasons I ran for council is that our charter too often has been taken as a suggestion in the past. So I think Councilwoman Gutwein will present a very formidable candidate no matter how we select and when we select these officers. But I would like to ensure that the voters who 30 years ago or more approved this language are not overridden by some policy that is misguided or does not comport with the language of the charter. Thank you.
Councilor Vincent.
Yes, I guess I'd just like to say when it was presented, I supported both people. I supported Councilor Gutwein and I supported Councilor Abel. I now feel that I'm almost in a position where, for me, it's all or none. And I hate to say that, but I think we're dividing it. And if we're going to look at the charter, and if that's what we're going to use, not to nominate one, then I personally am going to have to, unfortunately, vote not to nominate either. And that makes me very uncomfortable. And about the only thing I had up here was my word. And I gave my word to two people that that's the way I was going to vote and that I was supporting this. And now that has just been tossed because of something that's come up here at the last minute. So that's all I have to say.
Councilor LeBear.
I would just agree with Councilor Vincent on that and echo what she's just said. I definitely agree also with Councilor Skilling. I think the procedures need some changing. But to me, this looks like it's a manner chosen by a previous council. And so I feel comfortable with moving forward on voting in support of Councilor Gutwein. And part of that is because she contacted me and asked me for her support. And I was happy to entertain that. I told her for me, that leadership, the role of being Mayor Pro Tem, I believed it was a leadership role, and it's important to make sure that whoever's in those roles is actually working to build bridges and find common ground. She indicated to me that she's been meeting with each council person and listening to their concerns and working to build relationships so we can focus on working together and getting things done, which is the reason why I decided to run for this position in the first place, to help out my constituents, to help out the city, and to move things forward. And that's what I look forward to doing, and that's why I want to move past this. And I'm happy to support Councilwoman Gutwein, and I hope you'll join me. Thanks.
Councilor Gutwein.
Thank you. Okay, so a couple things. I understand that people don't like saying that it's political, and nobody wants to see this get political. I think the reason that some of us feel that way, or maybe I'll just say that I speak for myself, is that when we've had this conversation, Councilor Franks mentioned, she brought this up at the very first meeting. That's true. And we have been working on that. But since then, we followed this process 2 times to nominate and select 2 people following that process. And so to now break from it at this moment feels political. And then, like we've said before, this is not breaking from the charter at all. And then the last thing, so then what I wanted to say from the beginning is just thank you so much for this great opportunity. It means a lot to me. This is my favorite job I've ever had on council, and it just means so much to me that Mayor Paul nominated me, and so thank you for that. And then also I want to thank everyone in our community who sent an email on my behalf today. I think we had over 70 people send a message of support, and so that just really meant a lot to me. In terms of experience and leadership, so I have been serving our community for years before I was on city council. I know I'm young, But I have worked very hard for my neighborhood and for my community since I've lived here. So I was a member of our HOA, proudly the youngest member of my HOA. I helped start the Sustainable Southern Gables neighborhood program, which was life-changing not just for me, but for many of the people in our neighborhood, and has now grown to have over 100 people that participate in that. Then I went on to participate in the sustainability plan, Lakewood's first ever sustainability plan. After that, I was on the advisory commission for an inclusive community for a couple of years. I have served on Dr. Cog. I have served in the legislative committee. I have served on the transportation and infrastructure committee for representing the city of Lakewood nationally and advocating for infrastructure dollars. Budget and audit committee. And so I believe that even though I am young, I do have the experience to do this job and to represent Lakewood in Mayor Paul's absence. Also, I want to talk about collaboration. It's no secret that we're in some of the most politically divided times nationally, and Lakewood has not escaped that. The times are divided, and I think that it's really going to take a lot of hard work and an open mind and an open heart to meet with one another and listen and break down those walls so that we can move forward together. And since the election, I have met with everyone up here for coffee. I have tried to listen, really listen to what the concerns are. And I've had the opportunity to meet with some of you more than once, and kind of try to get past the campaign and build a bridge and work together. And I'm really proud of that. And I think that the only person I didn't have a chance to meet with yet is Councilor Johnson, and she's been out of town. But we've had a chance to exchange emails, and I'm sure we'll meet when we get back. And Councilor Roybal, who we have talked to over the phone. The point is that it's going to take a lot of hard work, and I am willing to do that work. And even if you need to yell at me for 90 minutes during a coffee meeting, I will do that. And I will sit through it, and then at the end, I'm going to ask you for another coffee meeting and try again. Because I think that our job is to get past all of that and do the best that we can for our community. So, you know, I was going to tell you a little story, but now this is going on forever. So basically, I am really proud of the way that we did this in the past. I'm proud that I leaned across the aisle and I supported Councilor Johnson. I'm proud that I supported Pete Roybal. And I would love to ask for, even though several of you have already mentioned that you're not going to support me, I'd still love to ask you to reconsider and vote for me. Thank you.
Councilor Abel.
I agree with Councilor Vincent that if we wait, the presidency, the council president will probably be a thing of the past. And if the vote goes, and tonight I would prefer, as in my motion, I wanted both of these officer positions to be put off until after we decide on a more proper way to choose. By that time, the council president will have probably disappeared from existence, and that's fine with me. It is one of the things that Councilor Franks and I questioned from the get-go is where the authorization for council president came from, and no one's quite been able to find out. It seems to have appeared in policies and procedures some time past without being authorized in the charter or through separate ordinance. So if that goes away, fine with me. And if you still feel compelled to vote for me tonight, I certainly release you from any offer a previous commitment, and that goes for anyone else on this dais. So, thank you.
Councilor Skilling.
Thank you, Mayor. Just one point that Councilor Gutwein had brought up. I think in the past, it's my understanding, I'm making an assumption that these positions, since somebody mentioned it was a unanimous vote, that there weren't other folks that were interested. And I think that's a distinction that if we're going to be collaborative and if people are interested in these positions, I think it would be important that those people have a right to at least be a candidate for it. So I just wanted to raise that.
Councilor Harrison.
After listening to Councillor Gutwein's description of her abilities, I want to say this is the very reason why I will be supporting her for this position. She is a perfect example of the youth that serves on this council, and I think that it's really good to have good ideas and her energy in doing this. One thing that I would tell you, based on the fact that this motion came up, as Mayor Pro Tem, I can't continue Mayor Pro Tem indefinitely. I have my own business, and this is going to be difficult. I've given up some time frames, so I think it's important that we go ahead with this vote, and I would be supporting Dana for this particular role. I think she will, just as she has in the past, give everybody plenty of time to think about and get input, and I think that she brings the strength that we need to this. And I'd like to call the question.
Is there a second?
I second.
All right, there's a motion and a second to call the question. That's the vote that's before us. So please cast your votes. Let's see. Calling the question, right?
Voting to end discussion.
So that fails the 6-4. Okay.
I was wondering if everyone did have the sense of what the rule is to call the question. There's sort of a motion to call the question, a second, and then a vote on whether to end discussion and vote on the underlying matter, and that is per Robert's rules a supermajority.
Supermajority. So we will redo that. There was a motion and a second. Did you get the second, Tor, for that? To stop debate. And that passes 8 ayes, 2 nays, the nays being Paul and Abel. So with that, we will go to the motion. And that is number 44, the one that's before us. Please cast your votes. And that is a tie, 5-5, and that fails. The noes being Skilling, Franks, Rybal, Abel, and Beta. And wish we wouldn't have cut off debate, but I'm just going to take privilege right now, and I'm going to say something that I wanted to say. And that's unfortunate, because I came off a contentious election with my opponent, and it was wonderful to be up here and to ask for this council's support to have Councilor Johnson be my Mayor Pro Tem. And I am proud of that. I'm proud of the way that this council has followed that. I'm also proud of the way we followed the rules, okay? Those rules are in place, and we don't bend them because we're not sure, we might wait. And had the shoes been flipped a couple years ago, I think it would have been a little bit different. So I respect the wishes of council. I will not be nominating another pro tem, so therefore I will be going forward without a mayor pro tem. Ms. Franks, if you could please hold your comment till general business so we can keep going. Will the clerk please read item 6?
Item 6, Resolution 2017-45, appointing the President of the City Council of the City of Lakewood.
Okay, there's a motion on the floor. That person would be Councilor Charlie Abel. Motion, is there a second? A motion and a second.
I move for the adoption of Resolution 2017-45.
Second.
All right, motion is second. Any discussion? Please cast your votes. Councilor LeBeer? This is for, I'm sorry, Council President. And that fails. 7 ayes, or 7 noes, 3 yeas. The ayes, Paul, or the noes, Paul, LeBeer, Skilling, Gutwein, Harrison, Vincent, and Abel. So there we will not have council officers. Will you please read Resolution 46 into the record?
Item 7, Resolution 2017-46, appointing members to the Legislative Committee. And this is the revised resolution at your places tonight that actually has the members' names included.
So for the record, those members of the Legislative Committee on Resolution 2017-46 will be Councilors Johnson, LeBeer, Beta, Skilling, and Gutwein. Please ask for a motion.
Mayor, I move for the adoption of Resolution 2017-46.
Second.
A motion and a second. Any discussion? Please cast your votes. That passes 10 ayes, 0 nays. Will the clerk please read the next item?
Item 8, Resolution 2017-47, creating a Budget and Audit Ad Hoc Advisory Committee and appointing members thereto. And this also would be the revised ones at your place tonight.
So tonight, those 3 folks would be Councilors Harrison, Beta, and LeBeer. I'll ask for a motion.
Mayor, I move for the adoption of Resolution 2017-47.
Second.
Motion and second. Any discussion? Please cast your votes. Councilor Skilling, thank you. And that passes 10 ayes, 0 nays. Will the clerk please read the next item?
Item 9, Resolution 2017-48, creating the City Council Judges Salary Review Ad Hoc Advisory Committee and appointing members thereto. Again, you're voting on the revised resolution at your places tonight.
For the record, could you please state the members? For some reason I don't have.
My record says it is Charlie Abel, Ward 1, Sharon Vincent, Ward 2, Pete Roybal, Ward 3, Barb Franks, Ward 4, and Karen Harrison, Ward 5. Judge's salary.
Okay. So, duly noted. Please ask for a motion.
That's...
I think it's 48.
Mayor, I move for the adoption of Resolution 2017-48.
Second.
All right, we have a motion and a second. Any discussion? Seeing none, please cast your votes. And that passes 10 ayes, 0 nays. Will the clerk please read the next item?
Item 10, Resolution 2017-49, creating a City Council Ad Hoc Advisory Screening Committee and appointing members thereto. This also is the revised resolution at your places tonight.
Thank you. And the screening committee will consist of council members Abel, Vincent, Beta, Franks, and Harrison. Ask for a motion.
I move for the adoption of Resolution 2017-49.
Second.
Motion and second. Please cast your votes. And that passes. Oh, not everyone is. Councilor Vincent, could you please weigh in? Thank you. That's fine. Passes 10 ayes, 0 nays. All right. Next up, we have public comment. This is the point in the meeting where the public is invited to address the City Council on items that did not appear on the agenda. All comments should be directed to the City Council. I ask that all in attendance observe the decorum in the City Council chambers and refrain from applause or audible support or discord with the speaker. There is a 3-minute limit per speaker. Time limit, 3 minutes. Up here, it'll go green. When 2.5 is up, it'll go yellow. At the very end, it'll go red. And if you haven't finished, I'll politely ask you to do so. I'd ask that you please sign up to speak tonight if you haven't done so already. And Ms. Amar, it looks like you signed up under consent, but I don't think you wanted to speak under consent. So there's nothing to speak under consent agenda. Well, you can speak to general business if you'd like to. Yeah, come on down. The consent agenda is first reading ordinances, so there's not public comment. No, ma'am.
Good evening, all. Relative to the topic that you just voted on regarding officers of the council, I would like to remind us that in the last couple of years we've discussed the diversity of our 5 wards in Lakewood and how diverse they are and the complications that poses when making decisions and ordinances as if we were a homogeneous community, which we are not. We are everything from an urban city to a semi-rural. We have high, middle, low incomes. Each ward was established for a reason. We have 5 for a reason. We have 10 councilors and a mayor for a reason. I'm concerned that the election or the appointment of an officer is done without considering the diversity. I would like to propose that when you consider changing the charter and or the policy and procedures, wherever you think my suggestion is most appropriate, that 2 clauses be added. Number 1, that no wards shall continuously and sequentially hold the office of mayor pro tem. If Ward 5 had it last year, Ward 5 doesn't get it this year. If Ward 3 had it last year, Ward 3 doesn't get it this year. Let Ward 2, let another ward have it. We need to have the representation diverse in our officers, and I think it's important. It's symbolic. It is a leadership role. And there are plenty of people from whom to choose on this council, rather than repeatedly appointing the same ward that gives that ward an unfair exposure and advantage. Number 2, clause number 2, in an election year, no mayor pro tem shall be nominated that is up for re-election. We all know that incumbents hold an advantage in an election. When someone who is up for election is appointed or elected pro tem, it gives them a further and unfair advantage, making every appearance in place of the mayor, fulfilling their duties as rightly they should, essentially a campaign appearance. So I would like those 2 clauses to be considered, whether you feel it appropriate in the policy and procedures or the charter, however it can work. Again, that no ward shall sequentially serve in the mayor pro tem position repeatedly, and that if it's an election year, no councilor up for re-election shall be selected as the mayor pro tem. Lastly, I would like you, in your review of policy and procedures in the charter, to consider inserting an annual pay increase for the mayor and for the councilors. I would like to suggest a very conservative number of 3.5% be built into our system. We're not looking at 14% inflation rates like we did in the 70s and 80s. We're looking at a very low rate right now. 3.5 is very, very, very conservative. I think it's obscene what you guys, quote, don't get paid. Our mayor's job should be a full-time position, and the current salary of $37,000 does not allow it. A $12,000 old salary of a counselor does not allow the full attention and focus of you folks who have essentially volunteered for this. And like our fees to developers, we have not kept up to date with rising costs. And it allows for the temptation of politicizing elections, holding people beholden to their campaign contributors, special interests, being involved in things perhaps we shouldn't be. So I would like that considered as well. Thank you.
Thank you. That might be a first at the dais. I'm going to save that. Mr. Moeller, looks like you probably didn't sign up, so I doubt that. Come on down.
Mike Mueller, Ward 4. I was listening to the procedures on what is considered a conflict of interest and also on a quorum requests. And so I have just some questions. That's all I wanted to ask was if a candidate receives an enormous amount of money and say, like from a developer or a marijuana grower, just for instance, if that developer comes in and wants to build a project, should that candidate be, if he wins his election, should he recuse himself? That's one question. Who determines the privacy in a CORA request? If it's the city attorney, that could be very judgmental on what he wants released. And what about private equipment like phones, laptops that aren't city equipment? If he's doing business on those laptops or those phones, shouldn't we be able to attach those in a CORA request? These are just questions that I'm asking for, keep this wide open around here. If it's proven that when you ask for a CORA request and the information is not given, but if it's proven that you were hiding information, what kind of penalty should be judged? We need to have some kind of a penalty associated with that. The openness of this government has to be wide open. And if you have a phone it's your personal phone and you're talking business on it, and I ask for what's on it, I should be able to get it. Thank you. And if we could get those questions answered, I'd really appreciate it.
Thank you. Ms. Judson? And then Mr. Mace, you're up next. Good evening.
Thank you. Mayor and members of City Council, I just wanted to make one point. I do agree with, I was interested in the debate tonight, and I'm very appreciative of people that said that the mayor pro tem should be selected in accordance with the manner prescribed by the city charter. I think that's very important that we consider it like a constitution. We would change the policies and procedures to be in accordance with the manner prescribed by the city charter. In other words, the city council at large should be able to select a mayor pro tem, and that they should be able to take more than one nomination. So, thank you.
Thank you. Mr. Mace. Good evening.
Give me about 3 seconds, Mayor.
Good evening, Mayor, City Council members. I have a question regarding our smoking ordinance. Mayor, this question is directed at you. If we've got the smoking ordinance, why isn't it being enforced? Because every time I'm at a light rail station, bus stop, I'm seeing cigarettes, I'm seeing people not getting tickets like we used to. Our agents are not writing tickets, and I want to know why. This is something that it's making our community smell really bad. And yes, I am complaining because I'm tired of the smell. Thank you.
Thank you, sir. Anybody else? I saw Mr. Olson left, so yes, sir. Come on down. That's all right. Just give us your name, and if we have your address on record, just tell us your ward.
I'm Bill Furman from Ward 4.
You talking to the mic?
Sure.
Thank you.
I'm Bill Furman from Ward 4. I didn't really intend to speak, and so forgive me if I'm not terribly articulate in the moment, but I was a little disappointed because I feel like no one seemed to be clearly talking about what mayor pro tem means. You all talked about procedures, but obviously the intent, by the words of it alone, are for that person to represent the mayor. The mayor is elected. I don't feel like I need to tell you. I'm sure you use all of this, so sorry if my tone sounds more aggressive than it needs to be, but I feel like sometimes, whether it's politicized or not, and I believe you when you guys say you're not politicizing it, but I feel like somehow we're missing the point, and then it looks like it's politicized to the public, myself included. Because from my perspective, just thinking logically, the individual designed and intended to represent the mayor when the mayor is absent, it makes sense for that individual to represent the interests of the mayor. And frankly, it only makes sense to me that the person is appointed. The idea of electing them, I mean, that's why I get the idea of a president, frankly, but of your council, that is. But the idea of a mayor pro tem being something that has to be collaborative misses the point of it representing the mayor. And so if you want to make it something different than that, you probably should change the name of it. Thank you.
Thank you. Anybody else? All right. I will close public comment. And Ms. Greer, you might want to drink some water before you have to read all these into the record. So we're going to go into the consent agenda. We have no resolutions. All we have are first reading ordinances that appear on the agenda only for the purpose of setting future public hearing dates and ordering the newspaper publication of the proposed ordinances. No public comments will be heard this evening on first reading ordinances. The public will have the opportunity to comment on the proposed ordinances during the scheduled public hearings on the dates set tonight by City Council. Any council member may request an item on the consent agenda be removed for separate discussion and action under general business. Will the clerk please read?
The consent agenda consists of items 12 through 16 inclusive. Item 12, Ordinance 2017-15, amending Section 5.24.280 of Title V pertaining to business licenses and regulations, amending Section 6.01.010, 6.03.035, 6.04.030, 6.05.010, 6.05.033, 6.05.036, 6.06.010, and 6.07.100 of Title VI pertaining to animals, and amending sections 9.32.020, 9.41.050, 9.43.020, 9.43.060, 9.43.070, 9.70.030, and 9.80.020, adding section 9.50.045 and repealing sections 9.50.120 and 9.50.130 of Title IX pertaining to public peace and safety. Item 13, Ordinance 2017-16, amending sections 1.16.010, 1.16.020, 1.16.040, 1.16.050, and 1.17.100 of the Lakewood Municipal Code pertaining to general provisions, amending sections 5.25.070, 5.26.070, and 5.47.280 pertaining to business licenses and regulations, amending section 6.08.020 of Title VI pertaining to animals, amending section 12.17.150 of Title 12 pertaining to streets and sidewalks, amending section 13.12.070 of Title 13 pertaining to water and sewers, amending sections 14.02.070, 14.03.070, 14.04.070, 14.05.070, 1406.070, 14.07.070, 14.8.070, 14.09.070, 14.10.070, 14.18.8080, 14.20.060, and 14.24.070 of Title 14 pertaining to buildings and construction, and amending Section 15.01.070 of Title 15 pertaining to Housing Code. Item 14, Ordinance 2017-17, authorizing the purchase of real property from the Vernon F. Taylor Jr. Revocable Trust for open space, park, trail, and municipal purposes, including acceptance of a deed from the seller, conveyance of a deed to Jefferson County for purpose of imposing an open space reverter clause, acceptance of a deed from Jefferson County, and approving a supplemental appropriation for the 2018 fiscal year from the Capital Improvement Fund and the Open Space Fund. Item 15, approving the minutes of the City Council regular meetings of September 25th, October 9th, and October 23rd, all 2017, and the City Council special meetings of October 16th and October 30th, 2017. And item 16, accepting the minutes of the Advisory Commission for Inclusive Communities executive committee meeting of October 4th, 2017, their full commission meetings of September 20th and October 18th, 2017, the Board of Appeals meeting of October 17th, 2017, and the Lakewood Planning Commission meeting of August 23rd, 2017.
Well done.
The end.
Can I have a motion on the consent agenda, please?
Mayor Paul, I move for the approval of council minutes for acceptance of the minutes of boards and commissions, order all ordinances introduced into first reading to be published in the Denver Post with public hearings set for the date included in the ordinance, all of which are included in the consent agenda items introduced into record by the city clerk.
Second.
All right, we have a motion and a second. Any discussion? Seeing none, please cast your votes. Passes 10 ayes, 0 nay. Okay, so under general business, I'm going to turn it over to Councilor Vincent.
Yes, I'd like to introduce and direct, I think, folks to look at the adoption of a nuisance ordinance. Right now, there's a lot of businesses where there are increased calls for service, and these range from repeated police presence to repeated calls for code enforcement. These businesses, quite frankly, don't acknowledge, nor do they oftentimes attempt to even improve their situation. Currently, departments are unable to pursue actions which it could impact the situation. So by adopting a nuisance ordinance, it will allow another enforcement tool not currently available. Nuisance ordinances have been utilized, in fact, in other jurisdictions with success. I think there would be a positive financial impact, but although I don't know that, so I'd have to have people investigate it, simply because there's places where we've had repeated police presence, SWAT teams, hostage situations. We've even had those enforcement tools, or those, what am I trying to think of? I'm sorry. Code enforcement, where they come and they say, yeah, they'll take care of it next week. And there's really no enforcement to be able to get them to move on to do those things which they are supposed to comply with. So I think that it would behoove us to look at another tool that we could give our police force and our code enforcement people a chance to work on.
Councilor LeBear?
Yeah, I just wanted to say that I'm looking forward to working with Councilor Vincent, and I'm in support of taking a look at this discussion. So I'm excited about that. So thanks for bringing it up.
So the idea would be asking for direction to have staff start to look at these sort of things and bring it back to council for a study session. Okay, Councilor Abel?
I heartily concur with Councilwoman Vincent. We have nuisances of all sorts in all of our wards. It is difficult to explain to citizens why we can't enforce these things, and we need some teeth in a number of our regulations, and this one especially. So I'm all for following through on this with a study session, and have staff bring to us some suggestions.
Councilor Roybal?
I too would look forward in seeing something like that, because we do also have similar situations in our ward. So I wholeheartedly support you in that.
All right, so is there a consensus from council to move forward? All right, looks like that. So thank you. Thank you for submitting that as well. Councilor Skilling has submitted some, and those will hit the packets and be in the agenda for January 8th. Anything else under general business? Ms. Hodson, executive report.
Yes, thank you. Please make sure to mark your calendars. We were finally able to schedule a joint a regular meeting with the school board to talk about parking at Lakewood High School. We've gone back and forth, and that'll be held here in the council chambers on Monday, February 26th. So that's a regular meeting probably on your calendar already, and we will host the school board. And we will certainly have public comment at that time, and we will hear from the parking work group. So that's February 26th. I'm delighted that that's finally a date that we can count on. So here's some good news. We recently we saw a graduation of 16 police recruits who graduated from the academy, and they're ready to start their 16-week field training program. So that's great news. 16 recruits graduated just last week. At our Lakewood Lights event, we had record attendance, 1,300 people this year, including little kids, which was really cool. And finally, I want to just mention we will be having a continuation of council orientation on January 8th, and I believe that's at 5:30. And we'll go through, this will be a in-person orientation. We'll go through a lot of important information for you. As the mayor had mentioned, we will have the video from tonight on kind of the legal 101, legal issues. We'll have that available, and we'll post that. So if you want to see it again or you want to reference it to constituents, et cetera, we'll have that available. And we're real open to feedback in terms of the different methods that we're using for orientation. And finally, just some really great news, just in case you don't have enough stress in your life, we have 14 days until Christmas. That's it. Thank you.
Thank you. I'm going to start all the way down on my left. Councilor Beta, do you have any announcements or? Yes. Want me to? I'll come back, certainly. Councilor Abel?
I would like to note that Jefferson County's open space is celebrating its 45th anniversary. 45 years of preserving, protecting, and providing open space in Jefferson County. A number of our open space acquisitions have come through this program. It was a very forward-looking thing. 45 years ago, the citizens of the county voted to tax themselves, and we reap the benefits every day. Thank you.
Councilor Vincent?
No report.
Councilor Roybal?
Just a quick reminder, we're not going to have our Ward 3 meeting here in December. It's real close to Christmas, so we'll pick it up in January. Thank you.
Councilor Harrison?
No report.
Councilor Franks?
Thanks, Mayor Paul. Wanted to first and foremost thank everybody who came out and spent a very gorgeous Saturday with us for our Ward 4 meeting this past weekend, and for the really warm welcome for new Councilor Dave Skilling. Everyone was very gracious, and we had a really good meeting. I did want to let folks know that we are soliciting to try to understand maybe speakers that you want, and the one we heard was that after Karen Harrison sold the wonderful presentation by Stephen Bell, we did have a request for that, so we'll be reaching out to him with the Jeffco Schools to get a presentation. And the last thing I wanted to remind folks of, I continually see on Nextdoor and get personal reports of people saying, my truck was broken into, it was rifled through, and then I'll wait several months and I'll go look at the crime stats and not see that show up on the crime stats. And those are used in a variety of ways for us to know where we're seeing increased crime and where areas may be kind of shifting. And so I want to make sure folks know that Lakewood's made it very easy on you. Obviously, 911 for the emergencies, 303-987-7111 for any non-emergency ones where you need an officer to respond, and some really great online forms for reporting all kinds of property things where you don't, at this point, they just rifle through, took some change, you don't need them to do anything, but you still want that to be recorded so our police officers can kind of be assessing neighborhoods and making sure that they're adjusting their patrols and they're staffing correctly for the community needs. So that's all I wanted to share. Thank you.
Councilor Gutwein?
Thank you. Just wanted to say the Action Center has their Santa shop open, and I will be volunteering with my neighborhood on this Thursday, and we have an extra spot. So if anyone would like to join us, we'd welcome you, and I'm sure they have many other opportunities to serve as well. Thanks.
Councilor Skilling?
Thank you, Mayor. And I would just echo what Ms. Hodgson was referring to with 14 days to Christmas. So we happen to have some spots in this city where you could buy wonderful toys. You've got the Mills back in business. There's certain toy shops that may or may not be within a really short radius to where we're sitting tonight. So give Amazon a break and buy here. At least one day buy local. You got 14 days. So thank you.
Well said. Councilor LeBeer.
I don't have anything to report. Thanks.
Great. All right. So, thank you. Thank you. Yes, sir. It's all yours.
Thank you, Mayor. I just wanted to report that Councilor Roybal and I had a very interesting meeting this week. We were invited to a meeting of a development commission, I guess for lack of a better term, by the City of Denver. And they're looking at making recommendations on the redevelopment of the property, which is within the City of Denver, but it's in Ward 3 as well, at Jewel and Sheridan. It consists of 64 acres and 35 different owners, I believe is what they told me, of this property, if you can imagine. And so they're looking at redevelopment of that property because they're concerned about the blighted condition of, if that's a fair term, of the property. So they invited Councilor Roybal and I to come in and listen to some of their proceedings and to give our take as neighbors of the city of Denver as to what we think the folks in our ward might be interested in seeing and that sort of thing. So it was a very interesting meeting. They're going to be putting out their recommendations within the next 30 days, and we will be sure and share that with everyone as soon as we get them, written recommendations. And we certainly appreciate, I want to say we really appreciate the City of Denver reaching out to us, allowing us to participate in that. They certainly didn't have to do that, and to give us an opportunity to voice some of our concern of our constituents, was very much appreciated.
Great. Thank you. All right. So I just have a couple things. The Broncos won, so that always makes Monday a lot more tolerable. O'Kane had their house lighting party last week, which was really cool to see the O'Kane house. And thank you to the volunteers, because it sounds like the first set of lights that were put on were stolen. So thank you for the community coming together to make sure that they could still have that take place. So now we have all of our committees set, so look for monthly updates from council. I'd really like to hear from the council on your committees and what you're doing. I think the community would really appreciate that. You received an email about the retreat and a potential date. If you could please respond to Donna, that would be very helpful. I think we've only heard from 4 council members. I would like to say that I'm very proud of Dana, of Councilor Gutwein, and her willingness to engage. There was some talk about maybe a lack of outreach, and I actually put out in an email that Councilor Gutwein would be nominated by myself, and she took it to heart to really reach out. And as far as other people go who wanted this same role, I don't think that happened. So to her credit, I appreciate that. I appreciate her integrity and her willingness to put herself on the line knowing that it could end this way. And that says a lot. And the fact that the last 2 years you've been there to support people who may not have been very comfortable for you to support. So that's what leadership's about, and I appreciate that. I wish you all a Merry Christmas, Happy Holidays, Happy Hanukkah, and we'll see you on January 8th. Thanks.
If man is still alive, if woman can survive, they may find in the year 35. I'd ever been dreaming of. But she was bad, I didn't know it. Her pretty smile never did show.